The district court, and this was affirmed by the circuit court, only looked at the instant the shot was fired. And there is absolutely no case law, even in dogs, that doesn't consider the totality of circumstances. At some point, the officer has some constitutional rights to it, and has a right to due process. And that includes looking at everything that occurred leading up to his decision.
It did not seem to me, but I'll go back and read the record, but it did not seem to me that the district court or the circuit court treated the drive stun weapon as a dangerous weapon. Again, words like merely, or benign, or merely pain reviews. Is that a problem for the prosecution?
I don't think it's a problem. I can't recall those exact words being used, but I do think it's a fair consideration for the district court and for ultimately a fact finder at a trial to determine what the taser's capabilities were at the time. Certainly, a jury could agree with the defense that he was in immediate danger of harm from the taser, but that's a question that must be submitted to the jury after they consider the conflicting evidence that he was just simply trying to get away. That there was no evidence during that struggle that Mr. Lyoya intended to use that taser to hurt Officer Schurr, and whether or not how that plays into his honest and reasonable belief. All questions that must be submitted to a jury under this reasonableness analysis. They're saying I can use deadly force and met with force, and that's it. There's no parameters, there's no safeguards on there. So force could be as simple as a push. Force could be as simple as throwing my keys at you. And to say that an officer can lawfully use deadly force against someone who merely shoves them, what that means in the course of this case is that Officer Schurr could have shot and killed Mr. Lyoya almost at the instant he started running away. And that's not the law, that's never been the law. And I know that they say in the brief that this is an oversimplification, that these are extreme examples, but I believe that it's necessary to go to these extremes because if this court is going to set a precedent that officers can use force when met with any force during the course of the arrest, I agree with Judge Feeney that we're going to have some results where there's people who are incompetent, there's people who have mental disabilities that don't know what's going on, they might be drunk, and all of a sudden they're at risk of being shot just doing their traffic stuff.
I respectfully disagree that this is going to turn into a situation where officers are going to just use deadly force when somebody walks away for no good reason. If only because the officers are not trained that way. And there are remedies when they do that. They will lose their jobs. Most officers love what they do and do it for reasons because they believe that they're doing good for the community. They will also get sued individually and on behalf of the department. And so there are rules and laws against when an officer can do certain things. He started with verbal commands and tried to arrest them, and then used more physical efforts, hand-to-hand combat. Then he used his taser. He continued this whole time with verbal commands, and it was only when 3 minutes had gone by in hand-to-hand combat that he would not listen to the officers, that the suspect had the taser, which is a deadly weapon. Did he say one more time about the taser and fired the shot?